Good morning, we're on the record. Okay. Good morning. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with DC Code Section 2-571 HC of the Open Meetings Act, OMA, I'm welcoming you to the regular scheduled meeting of the Alcoholic Beverage and Cannabis Board. This meeting has been conducted pursuant to guidance made available by the District of Columbia's Office of Open Government regarding electronic meetings held by public bodies. Electronic meetings by the ABC Board are authorized pursuant to Section 2-577A of the DC Code. Pursuant to the OMA requirements, notice of today's meeting was provided 48 hours in advance of the meeting on ABCA's website and on the District Central Meeting calendar. The notice includes the time, date, agenda, and call-in or login information for public participation. This electronic meeting has been hosted by a WebEx account provided by the District of Columbia government. Please address any questions or complaints to the OOG at opengovoffice@dc.gov. My name is Donovan Anderson. I'm chairperson of the board. I would like to introduce the other members of the ABC board who are also participating electronically. Please respond when I announce your names. Mr. Silas Grant.
Mr. Silas Grant, present.
Ms. Terry Jeanine Quinn.
Ms. Terry Jeanine Quinn, present.
Mr. David Meadows.
Good morning, Mr. David Meadows, present.
Mr. Ryan Jones.
Mr. Ryan Jones, present.
Good morning, Mr. James Turner.
James Turner, present.
The board has 6 members in attendance for the conduct of business today, and that constitutes a quorum. Before we get underway with today's hearing calendar, I need to make a few instructions very clear so that the conduct of these hearings is understood by everyone. There are 10 cases scheduled for this morning's calendar. Once your case is called, I will take a moment for IT specialists to elevate the rights for each party to enable their camera and microphone. And then and only then will you have the ability to enable your equipment. If your case is not being heard, you will remain mute and your camera will be disabled. At the conclusion of each case, the parties will have the option to leave. If the party chooses to stay, all cameras and microphones for the concluded case will be disabled. Should you have any questions or require technical assistance in the hearing, please submit them using the question and answer feature. Our first business this morning is the protest hearing status, case number 26, PRO 00050. Chicken and Whiskey, license number 103863. Good morning, Mr. Oriana. Can you please elevate the rights of the parties in this case?
Good morning. Cameron Mixon, access elevated. And that appears to be all I see. I'm going to check in the chat if anybody else is here for this case. Here.
Thank you.
It appears the ANC's representative needs to be elevated.
It's Kevin Cataldo, I guess ANC2F, or Stuart West.
David Rubenstein, he just wrote in the chat.
Okay. Let me know. I'm trying to multitask, so let me know when the person's been elevated.
For some reason, give me 1 second. I don't see them on my end. 1 second.
Okay.
Oh yeah, David Rubenstein, access elevated. And I don't see a Kevin. Do you guys see a Kevin?
Well, is Mr. Rubenstein from the ANC? We just need one ANC
Okay, yeah,
representative.
he's elevated.
All right, fine. Mr. Rubenstein, can you please come on camera?
Yeah, I'm trying to. I'm not
All
sure
right,
why it's not working.
if
Can you
you
hear me?
can't, then I can hear you. That's
Yeah.
fine.
Okay.
Mr. Mixon, can you please identify yourself for the record, sir?
Good morning, Mr. Chair. Cameron Mixon, counsel for the applicant. Cameron Cameron, Mixon Mixon.
Good morning, Mr. Mixon. I can see you, Mr. Rubenstein. Can you please spell and state your name for the record and your affiliation, sir?
My name is David Rubenstein, Rubenstein. I represent 2F01.
No, sir, you do not represent 2F01. You're here representing ANC 2F.
Correct. And I am the representative for 2F01. Yes.
Good, that's fine. And the reason why I made that
I got it.
demarcation is because when you're here, you're representing the ANC. Okay,
Yeah.
thank
Yeah.
you.
Yeah.
All right, good morning, sir. All right. Mr. Mixon, are there any preliminary matters in this case?
None for the applicant.
Mr. Rubenstein, are there any preliminary matters from your perspective, sir?
No. No.
If this matter is not settled, it is because it's a substantial change, a street endorsement. So this matter is scheduled for a protest hearing on September 23rd at 1:30 p.m. Are the parties familiar with the instructions, or do I need to read the instructions for a protest hearing?
I'm familiar with them.
I'm familiar as well.
Good morning. I just want to remind the parties that 7 days before the hearing, you're required to file the PIP. Failure by the side to provide the PIP, the board is empowered to prevent that side from relying on documents and or witnesses that have not been disclosed timely. So if this matter is not scheduled, I will see you on September 23rd at 1:30 p.m. Thank you for your presence today. Have a great day.
Thank you.
All right, thanks. All right, the next case on our calendar is case number 26 CMP 00005, Tipsy Lounge and Restaurant 1, license number 111411. Mr. Oriana, good morning. Again, can you please elevate the government and the licensee in this case, please?
Good morning, Alicia Hogan Miller, access elevated. And
And to be clear, Mr. Chair, our office is not involved in this matter. I can be de-elevated.
apologies. Yep.
All right, all right, sir. Thank you.
And that's all I see right now. I'm gonna check in the chat.
All right. All right, well. All right. Good morning, Ms. Hogan Miller. Can you please identify yourself for the record, please?
Good morning, Assistant Attorney General Alicia Hogenmiller, ALYCIA HOGENMILLER, on behalf of the government.
Good morning, ma'am. There is no representative here from the licensee, but at show cause hearing status, there's no requirement that the licensee be be present. If this matter is not scheduled, then it is scheduled for a show cause hearing on September 16th at 1:30 p.m. I just want to remind the parties that they are required to file documents and witnesses they will rely upon 7 days prior to the hearing. Failure by either side to timely disclose documents and or witnesses, the board is empowered to prevent that side from relying on documents and or witnesses that have not been timely disclosed. Any questions, ma'am?
No.
All right, thank you. Then we have now dispensed with that case. All right, the next case on our calendar is case number 25 CIT 00585 Ollie, OLIEE PIU. The license number is 122182. Mr. Oriana, can you please elevate the licensee in this case?
Okay, Manala Mahmood, access elevated, and that appears to be all, Chairman.
Thank you. All right, good morning, Ms. Hogan-Miller. Good morning. Can you please identify yourself for the record, ma'am?
Assistant Attorney General Alicia Hogan-Miller, ALYCIA, HOGENMILLER, on behalf of the government.
Good morning, Ms. Mahmood. Can you please spell and state your name for the record and identify yourself, ma'am?
Hey, good morning, Mr. Chair, members of the board. Manal Mahmood with Malius O'Brien Sandground for licensee MANALLE MAHMOUD.
Good morning, ma'am. Ms. Hogan-Miller, are there any preliminary matters in this case?
Nothing from the government.
Ms. Mahmood?
No, Mr. Chair.
All right, so if this matter is not settled, it is scheduled for a show cause hearing on September 16th at 10:30 a.m. I would like to remind the parties that they are required to file 7 days before the hearing the documents and witnesses they will rely upon at the hearing. Failure by either side to timely disclose the documents and witnesses, the board is empowered to prevent that side from relying on documents and or witnesses that have not been timely disclosed. Any questions by either party?
No.
No.
Well, thank you for your appearance today. Have a great day.
Thank you, Mr. Chair.
Thank you. All right, the next case on our calendar is case number 25 CIT 00424 BAMIS, license number 128057. Mr. Oriana, good morning. Can you please elevate the rights of the licensee in this case?
Yes, Bernard Gibson, access elevated, and that appears to be all, Chairman.
Thank you.
Good morning.
Good morning, Miss Hogan-Miller. Can you please identify yourself for the record?
Assistant Attorney General Alicia Hogan-Miller, ALYCIA, HOGENMILLER, on behalf of the government.
Good morning. Good morning, Mr. Gibson. Can you please spell and state your name for the record and your relationship to this establishment, sir?
Good morning, Bernard Gibson, BERNARD GIBSON. I am the owner.
All right, good morning, Mr. Gibson. Ms. Hogan-Miller, are there any preliminary matters in this case?
No, an OIC agreement was sent for signature, and once it's signed, it will be submitted to the board.
Mr. Gibson, the representation by the government, do you have any preliminary matters to bring to the attention of the board?
No, sir. I'll be signing and paying the fine.
Well, if you want to, if you agree to the terms of the OIC, Ms. Hogan-Miller could put it on the record and we could approve it today. Or do you want to? It's your option.
I agree.
Well, so Ms. Hogan-Miller, since Mr. Gibbs is not contesting, why don't you put the terms of the offer and compromise on record and the board will vote to approve it rather than waiting for a signature?
Yeah. Yes, Chairperson.
If you have it available, ma'am. If you don't have it, then
I have it available. The sole charge is failing to file a required quarterly statement. This is a first secondary tier violation. The statutory authority is DC Code Section 25-113B2A. It's a $250 fine paid within 30 days, or the license shall be suspended indefinitely until the fine is paid. That is all.
Mr. Gibson, it's my understanding there's an offer in compromise. The offer in compromise that there's a fine of $250 paid within 30 days. If the fine is not paid within 30 days, the license will be suspended indefinitely until the fine has been paid. Is this your understanding, sir, of the offer in compromise?
Yes, sir.
Are you aware that by accepting an offer in compromise that you're giving up your right to a hearing?
Yes.
Are you also aware that by accepting an offer in compromise, you're giving up your right to appeal this matter?
Yes.
As I said, I therefore make a motion that the offer in compromise of a fine of $250 paid within 30 days be accepted. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Jones,
Mr. Jones, I agree.
Turner,
Turner, I agree.
Mr. Anderson, I agree. The matter passed 6-0. What this means, Mr. Gibson, you have 30 days from today to pay the fine, and there's no further action by the board. You pay the fine within 30 days. The board will issue a board order today. You have 30 days to pay the fine. All right.
Thank you. Yes.
Thank you for being here today, sir. And you guys both have a great day. Thank you very much.
Thank you. Have a good one.
All right. All right, the next case on our calendar is case number 25, CMP 000018, the HARP, license number 1333946. Mr. Oriana, can you please elevate the rights of the licensee in this case?
On my end, it shows canceled.
No, I don't believe so, because I'd asked the question. Let me look at I don't believe so. Let me look at the attendance. Let me look at the attendee, because I did ask the same question this morning. I was told no, but unless there was an issue, hold on. Let me see something. Let me see, hold on. The HARP is 0018. I did ask the question this morning, but this case has been canceled. This matter is canceled. An offer in compromise has been provided to the board for its review and consideration. Okay. All right, the next case on our calendar is case number 25, CIT 00453. It's Death Punch, Shabu Plus, and Shabui Eatery, license number 114937. Ms. Oriana, can you please elevate the rights of the licensee in this case, please?
I don't see Darren Norris, but I'm checking in the chat.
Okay, fine. All right, well, Ms. Hogan Miller, good morning. Can you please identify yourself for the record?
Assistant Attorney General Alicia Hogan Miller, ALYCIA HOGENMILLER, on behalf of the government.
Good morning, ma'am. The licensee is not here. However, there is no requirement for a licensee to appear for a show cause hearing status. If this matter is not settled, it is now scheduled for a show cause hearing on August 12th at 1:30 p.m. I would like to remind the parties that remind the parties that 7 days before the hearing, the parties are required to file documents and witnesses. Failure by either side to timely disclose documents or witnesses, the board is empowered to prevent that side from moving forward. If there's no other questions, Thank you, ma'am, for your appearance today. Okay, thank you. All right, hold on a minute. All right. All right, so the next case in our calendar is case number 26 CC 00001. The District Cure Dispensary, license number 127161. Mr. Oriana, can you please elevate the rights of the licensee in this case?
Sure thing. Meredith Kinner, access elevated. And that appears to be all. I'll check in the chat.
Well, I will ask Ms. Kinner. I know she's an attorney for a client who's going to be here. All right, so let me.
No,
Okay, fine.
no,
Thank you.
my client is not
All
here this morning.
right. Good morning, Ms. Hogan-Miller. Can you please identify yourself for the record?
Assistant Attorney General Alicia Hogan-Miller, ALYCIA HOGENMILLER, on behalf of the government.
Good morning. Ms. Kinner, can you please spell and state your name for the record and your affiliation with this case, ma'am?
Yes, Chair. Good morning. Meredith Kinner on behalf of the respondent, District Cure Dispensary, MEREDITHKINNER.
Good morning.
Good morning.
Ms. Hogan-Miller, are there any preliminary matters in this case?
No.
Ms. Kinner, are there any preliminary matters in this case?
No, Chair.
All right. If this matter is not settled, it is now scheduled for a show cause hearing on August 12th at 1:30 p.m. Just want to remind the parties that at show cause hearings, you are required to disclose documents and/or witnesses 7 days before the date of the hearing. Failure by either side to timely disclose documents and witnesses, the board is empowered to prevent that side from relying on documents and/or witnesses that have not been timely disclosed. Any questions by either party?
None from the government.
No, Chair.
All right, thank you for your presentation here today. Have a great day.
Thank you. You as well.
Thank you. All right, the next case on our calendar is case number 26-251-00009, 12 after 12, license number 117238. This case is canceled due to the submission of an offer in compromise for the board's consideration of an approval. The next case in our calendar, it's a motion hearing. It's Kick-Ack Throw Social DC license number 133556. Mr. Orietta, can you please elevate the rights of the parties in this case, the government and the licensee?
Sure thing. Cameron Mixon, access elevated. And Sophia Matus, access elevated. That appears to be all, Chair.
And there should be one of the licensees, Mr. Ricky Singh, on as well.
You said Ricky Singh?
Yes.
And who are you waiting
Ms.
for?
Hogan-Miller, she's my second chair on this matter.
I don't see Ricky.
Okay, she's back. Okay.
Can you check, Cameron?
Or if not, Mr. Singh, Mr. Karam Uzman.
There is a call-in user, but I don't see Usman.
It may be the call-in user.
Call-in
Is that-
user, press *6, I believe, to unmute.
Do you know if that's a number for that person or the 59 number, Mr. Mixon?
Yeah, is this the court reporter or call-in user?
Call-in user, can you please identify yourself? Mr.
I
I
believe
think
it's
that's the court reporter. Then I think it's called. Mr. Mixon, can you find out where your client is, sir? If you need to have your client here today.
I'm checking now. And if not, considering this is a motion hearing and oral arguments, I imagine we could proceed otherwise.
That is your call, Mr. Mixon. You are if the motion's here, and if you don't need your client to be here, that is fine. All right, so let's start with you, Ms. Meadas. Can you please spell and state your name for the record?
Good morning, Assistant Attorney General Sophia Meadas, appearing on behalf of the district. SOPHIA
Good morning, ma'am. And you're been told that you're being assisted today by Ms. Hogan Miller. Can you please introduce yourself for the record, ma'am?
Good morning again, Assistant Attorney General Alicia Hogan-Miller, ALYCIA, HOGENMILLER, on behalf of the district.
Good morning. Mr. Mixon, can you please identify yourself for the record, sir?
Cameron Mixon, counsel for the licensee, CAMERON MIXON.
You had made representation, sir, that you were expecting a client to be here. Your client is not here. I don't know what's going on with your client, but you wish to proceed without the client, sir.
Yes, that is fine.
All right. Now, Ms. Hogan Miller, I guess it's a motions hearing from the government. So can you provide some background why we're here today, ma'am?
Ms. Meadas is the first chair, so I'll turn it
I'm
to
sorry,
her.
Ms. Meadas, I apologize. I've been working with Ms. Hogan Miller all morning, so I do apologize, Ms. Meadas. Go ahead, please.
That's all right. Good morning, members of the board. The district is here today to present objections to Throw Social Security Plan. The security plan that was recently filed with the board is not consistent with the licensee's preceding security plan, which included terms from a 2024 offer and compromise that counsel for Throw Social agreed was still applicable when we last appeared before the board on April 22nd, 2026. So the district will ask this board to find that the current security plan is not in compliance with the records on file with the board and order Throw Social to amend it within 15 days or face suspension under DC Code Section 25-836D. And I can walk through some of the background of the situation. This case came out of a summary suspension in which Throw Social had permitted a promoter to host a concert in the upper level, which has a capacity of around 300, but the promoter had sold over 600 tickets. And around 12:30 a.m. on April 12th, 2026, MPD responded to the scene because there was an injured patron outside. There are approximately 400 patrons inside and 200 were queuing outside. So the scene was incredibly chaotic. MPD determined that the establishment needed to be closed for public safety, and it took almost an hour to clear patrons from inside and outside, and several fights broke out, including a stabbing. So MPD summarily closed the establishment for 96 hours, and ABCA followed up with a summary suspension. And ABCA was especially concerned that night about the violations that they saw, which included being oversold by the promoter, being over capacity, advertisements to patrons under the age of 21, and that the promoter was allowing the patrons inside without proper search. And that was an issue because in November 2024, Throw Social was also summarily suspended for an incident involving a stabbing. And we know on that night, again, security did not properly search all patrons. Specifically, the patron who committed the stabbing had been on the premises earlier for a private event and was not searched before he remained in the venue when it opened to the public. So that summary suspension was resolved with an offer and compromise, which required the implementation of a security plan and requirements including how to search patrons for public versus private events, a long-winded description and definition of a private event, which specified that private events cannot be hosted by promoters, and an outline of security personnel staff numbers and training requirements. As we know, the establishment and license was sold to a live entertainment of DC LLC in March 2026. And the management, Mr. David Nomak, remained on the team after the sale. The operations remained consistent. The name and the type of entertainment offerings were consistent with prior conduct. Now, on April 22nd, 2026, this board approved of an offer and compromise to resolve the April 2026 summary suspension. And that required the submission of an amended security plan to simply add new agreed upon terms. And the board lifted the suspension before the security plan was submitted at the request of the parties. The district, after receiving a copy of the security plan, raises concerns about missing terms to licensees council several times, but the requested changes were not made and responses were not given, so the district filed this objection with the board. And I'd like to briefly go through some of the key terms we are concerned that are missing from the 2024 OIC, which is a portion of term 1A, which prohibits promoters from hosting private events, a provision from 1B about searching patrons that exit and re-enter, especially if they're there for a private event earlier, 1F, which requires the establishment to call MPD in the event of offensive physical contact every time, not as necessary, which is what it says in the current security plan. And it requires incident reports and notice to ABCA, which is critical for ABCA to complete their investigations. We also noted missing language from 1G and 1H, which require cooperation with MPD and ABCA, and 1L, which requires retraining annually and within 30 days of a new hire. All of these terms are missing from the current security plan that was submitted after the 2026 OIC was signed. And we believe that these address significant operational issues that were evident in 2026, and that the 2026 OIC intended to simply add terms to that pre-existing security plan. So there are two reasons specifically why the security plan language required by the 2024 OIC should be part of the current security plan. First, when we presented the 2026 OIC to this board for approval, Licensees Council made several representations that the security plan language from 2024 was applicable and would be integrated. This was the only aspect of the OIC that members of this board had questions about, and Council reassured this board 3 times that the 2024 OIC still applies. The board approved the OIC based on these promises because the language of the security plan required by the 2024 OIC is necessary for key aspects of the 2026 OIC to be effective. If we would review the transcript, I'll just pull a couple of quotes. They stated that their client had informed Council that they were subject to a certain security plan provision provided by a prior offer and compromise, and are going to work to implement the procedures in this new offer and compromise. That's on page 23 of the transcript, lines 17 to 24. On page 28, lines 8 to 15, their counsel said they understand that both agreements have to be followed. And again, on page 29, around lines 3 through 8, they said they will incorporate the provisions required by both offers and compromise. It is after this representation to this board that the board approved of our offer and compromise in April. Second, there is language in the 2026 offer and compromise that indicates that we had agreed that the pre-existing security plan would remain in place and new terms would simply be added, or if there was a conflict, the new terms would supplant. So we agreed that the licensee would submit an amended security plan incorporating the terms. We use the term amended to indicate that there was already a document on file. The OIC also specified that the security plan would include new terms. So we didn't ask them to delete any terms. We didn't ask them to create a new security plan. We simply asked them to add new terms to their security plan. And after the district filed their objections, respondent filed a response. So I'd like to take a moment just to address those arguments that they made. First, they emphasize that DC code does not require a security plan to maintain specific terms when it's amended. And that's true. It's the board's order approving the 2024 OIC and again approving the 2026 OIC, which required the maintenance of a security plan with specific terms. Second, respondent asserted that the board's order deeming the 2026, quote, the entire agreement of the parties, end quote, means that the 2026 OIC no longer applies. And first, that is not language from the OIC. That's language that the board put in its order. The parties did not negotiate that term and therefore did not come to a common understanding of the meaning of that term. Second, that is a very common contract term called an integration clause. That simply means that this written and signed contract is a complete agreement on that subject matter, on that pending case. So any terms proposed during negotiation in writing or orally are not binding. So that does not reach back to prior agreements about other subject matters, which in this circumstance would be the 2024 OIC. If this board accepted respondent's interpretation of the entire agreement of the parties, then every agreement between two parties, regardless of the subject matter or the timing, would invalidate every prior contract just by virtue of their identity. This also conflicts with respondents' agreement to insert new terms into the amended security plan because that implies a pre-existing security plan. Finally, respondent has emphasized that the 2024 OIC was signed by a prior owner, and that's true, but respondents' counsel again stated before the board that it understood it was subject to that prior OIC agreement, and that OIC agreement led to the filing of a security plan, which is maintained in ABCA's files, that they again agreed that they would continue to follow. And the prior OIC terms, we believe, are still relevant to the new owner's operations because the establishment has maintained the same name, same management, same entertainment offerings, and same reputation. I'd like to note that the license transfer did not include any substantial changes that would indicate that the new owner sought to divorce itself from the prior operations. In closing, Throw Social has failed to maintain a security plan that is compliant with this board's requirements that are expressed in this board's orders approving both the 2024 and 2026 OICs. Throw Social told this board that it would incorporate the provisions required by both offers and compromise and has failed to keep its word. The district therefore respectfully requests that this board issue a notice to Throw Social to file a compliant security plan within 15 days or risk suspension. Thank you.
Thank you, Ms. Muniz. And I think before I ask you some questions, Mr. Mixon, this was a summer suspension hearing, and there was an offering compromise that was provided to the board because apparently it appears that the parties agreed what the terms were to allow the establishment to be reopened. And it appears that there is disagreement about what the offering compromise should have stated. So I guess a question I'll ask you for the government, I mean, since there's no agreement, should the board just void the offering compromise, and we move back to a summary suspension in the sense that the establishment should be closed because there's no agreement, and then we should have a hearing. What's the government's position on the board just revoking the voiding the offering compromise because there's disagreement between the parties about what the terms were, and just move to a hearing?
Yes, Mr. Chair. I agree that's a viable option. Of course, that's not in the establishment's best interest. However, we are dealing with a contract where it appears there was no meeting of the minds, so that is proper.
And another option, could the board just not do anything currently and will issue issue a show cause for failure to comply with the OIC security terms, and that we just move to a show cause hearing on that matter.
Yes, that's absolutely another option under the code. I just believe that the citation from 25-836D is the most direct route to compliance. That would give them 15 days to get the security plan in compliance. Again, we have concerns
what's
about
the section? I'm sorry, what's the section again, please?
25-836D.
And I don't have it in front. So what's 836D? What does that specifically state?
So it provides that the board, when it finds that a current or amended security plan is not in compliance with the requirements on file with the board, which could mean the code and the requirements in the code, it could mean OICs that are pre-existing, then it's the board's right to issue an order notifying the establishment and to give them 15 days to remedy that. And if that is not done within 15 days, the board may suspend their license.
Anything else, any other arguments the government wish to make before I turn to Mr. Mixon?
I did want to note one last aspect of the 2026 OIC that points directly to the 2024 OIC is we incorporated a term, capital P, capital E, private events. That is the term that raised this board's questions last time we discussed the 2026 OIC. And in the 2026 OIC, we had stated some terms about how private events need to operate. And that was based on a prior definition and prior understanding of private events that is in the 2024 OIC and then was in the security plan that predated the current one we're discussing.
Mr. Mixon, what's the dispute?
Thank you, Mr. Chair. Respondent or licensee's position is that it has fulfilled all responsibilities with respect to the 2026 OIC that resolved that aforementioned summary suspension. It did in fact file a security plan with the board that both complies with the suite of new terms established by the 2026 OIC to resolve the summary suspension, as well as all requirements under 25-836 for a minimally compliant security plan. Further, the OAG's position that the 2024 OIC remain in effect is not supported by the code. DC Code 25836F states a licensee may amend or replace an existing security plan on file with the board by filing a new security plan that is compliant with this section. Licensee performed its responsibility. It filed a new security plan that met all 8 requirements of 25-836G that lays out or rather E, that lays out the 8 sections, types of terms and provisions that a security plan should have. Upon review, it'll show that it has everything from the conflict resolution provisions through the procedures for preserving a crime scene that's required for a security plan. Respondent objected because at no point in the text of the 2026 OIC this board approved did it state that the 2024 OIC would remain in effect. The entire agreement as construed asked for the filing of amended security plan that incorporates new terms. That security plan was filed, it was amended, and it replaced the old security plan that was in effect following that 2024 OIC. That is what the code calls for, the replacement of old security plans with new security plans, either at the discretion of a licensee when their procedures change, or when required pursuant to board orders or agreements. That agreement was fulfilled. It did not state that the older security plan and its terms would survive. It said that it would be amended with a new security plan, which has happened here. Any concerns that may be had as to whether this current security plan is sufficient are necessary, both in that it meets the requirements of 836E, which the board policy is always to approve security plans that do meet that minimum threshold, and object only when somehow some part of 836E is not satisfied. That's not the case here. Also, in that at no point in negotiating the terms of this new security plan Was there any discussion substantively of mention of the 2024 OIC? The respondent, the licensee, entered into this agreement understanding that this would be the new security plan it would offer. And it's extremely robust in that it features terms lettered A through O, all of which it has implemented and trained its personnel on. Yes, it was respondent's intention and which it performs to have a new agreement. It's met its responsibility, and there's no authority stating that old security plans survive once they have been amended by a new security plan. OAG objected to this, but it is true that the 2024 OIC was signed by entirely different ownership. That was an OIC entered into as a result of an action based on a different owner's conduct. And then this owner, who took control of the license this year, entered into the 2026 April OIC, which was based on conduct of its own self under its own management, under its own decision making. And so this OIC is, in addition to being complying with the law, actually geared towards the operations under this licensee owner. So it's more effectively catered to address the security needs that have been established by the record for this ownership.
The problem that I'm having is that, as both parties are aware, the board is not involved in offering compromise. The board doesn't negotiate offering compromise. So when it's presented to the board accepts it. We will ask questions, and we either accept it, reject it. If the board rejects the offer and compromise, then the summary hearing, we move to a hearing. But so the problem that I'm having, I'm not quite sure what is it I can do if the parties are not on board what the offer and compromise is, outside of the fact that I'd ask, we can void our vote to accept the offer and compromise, and then we move back to a summary suspension hearing, or maybe the board can we can have a show cause hearing to say that it's not in compliance. But I'm not sure if the board is in a position right now to opine, because we're not part of the negotiation. These are the terms that the parties presented to us, and it appears that the parties are not in agreement what the actual terms of the offer and compromise are. And I think just to correct you, Mr. Mixon, as you're aware that you should be aware that the board orders, they do not become null and void because we have a new owner. So whatever board order, whatever settlement agreement that existed prior to the ownership change, it stays with the license. So if there was an offer and compromise with a security plan with the old owner, that still remains with the new owner, unless the parties specifically agree that we're gonna void the offer and compromise, the previous security plan and develop a new one. So I think that Mr. Mixon, what is your position? What's your client's position on the board vacating the offer and compromise? Because clearly it doesn't appear that there was an agreement between the parties what it is that they agreed to for the board to lift its summary suspension hearing, the summary suspension. And so therefore, if there's no agreement, then there's no offer and compromise. And so the board then should vote to void our vote. I think it said it was April 22nd to approve this offer and compromise, and then we move to the establishment will be closed, and then we move towards a summary suspension hearing. What's your position? What is it that you're asking the board to do in response to the government's position?
Yes, 2 points, Mr. Chair. With respect to the first, what remedy is appropriate in this instance, if the board finds that licensee has not performed its responsibility to file a compliant security plan, there's already a procedure in place in the 2026 OIC that addresses this. It's that failure, I quote, failure to file the amended security plan with the ABC board shall be a violation of DC Code 25-823A6 that calls for a show cause charge. The question here is not whether was the offer in compromise legitimate in the first instance. It was whether it's the board's position that licensee performed its responsibilities. We maintain that we have, in that the security plan before the board executes all relevant terms, all terms explicitly defined in that OIC. Which we invite the board to review and interrogate whether it does, and whether it meets the minimum requirements of a security plan under 836E. But if in whatever instance the board finds that it has not, then the filing of the show cause would be the more appropriate remedy than vacating the entire offer in compromise, which was entered into between both parties for all the words on the page. With full understanding and appreciation, and has addressed all policy concerns that gave rise to the underlying summary suspension.
But there's an option. The government is asking for you to amend, I think pursuant to 25-836D, that's the provision that was mentioned by the government, to say that, okay, you have 15 days to amend it. What's your position regarding amending it within 15 days? And I guess if it's not amended within 15 days, then I guess the next option would be there's a show cause here. So what's your position on what is it that was stated on the relevancy of 25 dash? And I don't have the provision in front of me, so I'm just I don't have it for me to read, so I'm just going by the representation by the government that 25-836D is applicable here.
I don't disagree. If the board makes the finding that this OIC does not licensee has not met its obligations with respect to either the OIC or the code on security plans, then the board's fully empowered to issue that notice, and licensee would obviously promptly comply as required. But in that the code seems to be, 836F seems to be extremely clear that the filing of new security plans replaces prior security plans. Then we invite the board to look at that, which clearly points to that the older OIC, which was required at one time, is no longer required because it called for a security plan that has since been amended and replaced. And the new OIC that was entered into does not direct the licensee to maintain those terms of that older OIC. It calls for them to be replaced. And this can be even seen in the specifics of certain terms, which directly overwrite parallel terms on the same issues from the 2024 OIC.
And forgive me if I'm not following, but it appears that there's a fundamental disagreement between the parties about what is it that the OIC requires. So I'm not sure if is it just a disagreement regarding whether or not the security plan is, yes, I'm going to come back to you, ma'am. And I said, correct me if I'm wrong. I'm not sure. I'm not sure if it's a disagreement whether or not the security plan is legally sufficient, or that there's a fundamental disagreement between the parties about what the agreement required. Was the agreement require that we amend the previous board order, or that we replace this board order with a new security plan? And that's what I'm hearing. So someone please correct me if this is my wrong interpretation. And I'm going to give the board an opportunity to ask questions if they so desire. So Ms. Mealis, I think you wanted to respond.
Yes, just to clarify on that point, there are 2 points of contention, but it's almost like 2 tiers. The first tier being whether or not the 2024 board order approving the 2024 OIC still applies to the license. And secondary to that is whether the parties had agreed at the time of the 2026 OIC that those terms that generated the security plan that they had in place on the night of the summary suspension would be carried through after adding the new terms in the 2026 OIC. So it's a double-pronged issue. I think it'd be incredibly helpful for the board to determine at least whether or not the 2024 OIC and that board order still applies to the licensee, just for their clarification.
Well, there's the board's position that the board order, it doesn't become null and void because we have a new owner. So that initial board order is still applicable to the license unless there is another order that specifically states that we are going to amend that board order or that security plan and replace it with new terms. So the board order is still applicable. So the board order under that was agreed to by the old owner, it's still applicable. That's the board's position. That's still applicable. The board order is still, unless this new offer and compromise specifically states that it will be replaced by this new board order. And I think that it appears that's where the disagreement lies, I think.
We don't disagree that board orders remain in effect unless amended. And here, functionally, that's what's happened. The 2024 OIC called for this filing of a security plan that had certain terms. That prior owner did perform that obligation, and this licensee inherited those terms. But with the filing of the 2026 plan, it called for the filing of a new security plan, which then effectively does replace the requirements under the prior board order. 25-836F establishes that new security plans replace old security plans. That board order, that licensee was subject to it for as long as they had that security plan. That was correct. And then they were required to have a new security plan, and the new security plan had to have 2 things: the suite of terms lettered 1A through 1O in the 2026 OIC, and all requirements 1 through 8 of 25-836E. And it has both of those.
Any questions by any board members? Go ahead, Ms. Quinn.
Mr. Mixon, the language you read.
I think you get a little bit closer to the microphone, please, Ben.
Yes, Mr. Mixon, can you hear me?
Yes.
Okay. The language you read to us, are you suggesting that that should be interpreted to mean there would be no circumstance under which an agreement could be amended and like just kind of within itself? You have the original agreement, we're going to make an amendment. Are you saying that that cannot happen under this direction, or that that cannot happen specific to this set of circumstances?
To clarify, are we referring to the amendment of the security plan that was required by the 2024 agreement?
I think what I'm referring to is the language you read to us. I mean, if I understood you correctly, you were using that to suggest that it's not, that the proper next step is to replace the old agreement with a brand new agreement, right? And that, what I was trying to reconcile is, are you saying that that is always the case, or that is the case just for this specific instance? Because if you're saying it's always the case, then that would mean that in no circumstances, under no circumstances, will we be able to direct a licensee to amend a security agreement without actually creating a brand new agreement.
Yes, I would say in all circumstances, the plain reading of 25-836F calls for the filing of new security plans. Let me go back to that language. May amend or replace an existing security plan on file with the board by filing a new security plan that is compliant with this section. That requirement is that a new security plan be submitted, and it may have substantially different terms from the prior security plan, but so long as it is compliant with 25-836, it has the all 8 of the required types of provisions, and the specifics of those provisions are not called for by the statute. It's just that they have provisions that address all 8. Then it is compliant, and it replaces the old old security plan, and licensee is no longer subject to that replaced security plan.
Okay, thank you. And Ms. Meadus, can you remind us, what is it specifically that you believe to be the harm with replacing the old agreement with this new agreement? Is it that you believe that there are specific provisions that are missing, or is there something else?
Yes, so there are 6 security plan terms from the 2024 OIC, not necessarily the entire term, but aspects of it. And the one we are most concerned about, which is actually a fact that came up in the board's hearing about the 2026 OIC, is whether promoters can host private events. So private events was created as a term of art for the security plan in the first OIC. And 1A of that OIC explicitly prohibits promoters from hosting them, because our concern was that promoter events are open to the public, and we had agreed that private events are not subject to the full wanding and bag search procedure that we usually expect from a public event. So that's one. Another one is 1B, about searching patrons that remain on the premises after a private event when the establishment opens to the public. That was directly related to the summary suspension in 2024, but that's an ongoing concern about security and weapons being brought in, because again, this year we had another stabbing. For the other ones are 1F, 1G, 1H, and 1L. Those all concern what staff are expected to do. Number 1 is that staff need to call MPD anytime there's offensive physical contact or a weapon. In their current security plan, they say, quote, as necessary, which then puts that judgment into the licensee's hands, which is incredibly concerning, because they could be in a position where they decide, oh, we don't need to call MPD because we don't think it's that serious, but that could be a matter that you need MPD to respond to for the safety of everybody. They also don't have a provision that requires incident reports and notices to ABCA. Those are essential aspects of ABCA's investigatory process. Getting those incident reports can help us identify the staff that are included in the incident, staff that may have more information. Then, of course, the requirement to have staff cooperate with MPD and ABCA, and retraining them annually and within 30 days of a new hire. The annual retraining obviously is essential. Memories fade. There may be changes in operations that occur throughout a year that are inconsistent with the security plan. So it's incumbent upon the licensee to revisit their security plan, revisit terms that they agreed to, that the board has ordered them to follow every year with their employees, so that they are actually following it. I mean, that last term is genuinely in the best interest of an establishment at all times, but truly our greatest concern is about promoter events and their disregard for how we had defined private events earlier.
Thank you for that. And so just to make it plain for the record, it's your position that when Mr. Mixon presents to the board that the new agreement essentially incorporates, it satisfies all the old provisions, he's either wrong or being disingenuous. Is that the bottom line here? Okay.
Yes, I have reviewed the current security plan and highlighted where the terms are missing, and it is certainly compliant with their agreement in 2026 to add new terms, but it's breaching the 2024 board order on the 2024 OIC. And again, that goes into our understanding when we went into the 2026 OIC, because we were reading the security plan that came with our case report that applied to the establishment on the night, and we said amend to add new terms. To amend and to replace are two completely different things, and that's why the code section that Mr. Mixon has been citing separates those two. They say amend or replace.
Okay, thank you for that. Mr. Chair, nothing further from me.
Thank you. Any other questions for any of the board members? Go ahead, Mr. Meadows.
Yes, Ms. Matus, in the OIC, it was agreed to that the security camera system would contain at least 26 security cameras. That was a number that was agreed to. On the plan that I see, there is no identification of a number of cameras. Is that an issue that you have also?
I have been looking exclusively at the 2024 OIC, but if that's an issue that the board has identified, I'd happily return and review it against the 2026 OIC as well. We have been told by our investigators that the establishment has been working with him to place cameras as needed, and they're in a good spot in terms of physical compliance with that term.
Thank you very much. Thank you, Chairman.
Thank you. Any other questions by any of the board members? Trying to get a. Go ahead, Mr. Turner.
Mr. Mixon, is your contention that the 24 order of offering compromise said shall submit a security plan to be a new plan?
To be clear, the 2024.
Yes.
If you board's indulgence, let me read the relevant section. Yes, that offer 2024 reads: respondents shall submit a security plan to ABCA and the Office of Attorney General, and it would be reviewed by the board.
Okay.
So yeah, that was, I guess, the first plan that they had.
So that's a starting point. So then if we move to 26, it says the respondent shall submit an amended security plan. So this would be amending the prior one, correct?
That is correct, yes, with a new suite of terms.
But not replacing. It's amending, and in effect, it's a new one, but they combine. Correct?
I mean, amendment of security plans, as set forth by 25-836, is that provided that it is compliant, the security plan can state any number of different things, which in effect permits any amendment to be a full sale replacement, provided that it is otherwise capturing what was intended by the construction of 836, that it have a certain set of types of procedures.
So your contention is not that the old one carries forward amended, but that a new one created compliant with basic requirements and the items laid out becomes a new one. So the provisions of the old one are no longer considered.
That is correct, and that has been board practice on security plans. Generally, the board rarely, if ever, objects to the substance of a security plan, just whether that it meets whatever basic requirements are laid out in 836, or that it meets what was set by the offer and compromise that ordered the filing of a new amended security plan.
Okay, so now to the government contends that the 1 and 24 shall be amended and all the provisions in 24 carry forward into an amended revised version. Is that correct?
Yes, Mr. Turner, that is correct. And there is, to my knowledge, one explicit term that conflicts, and that was an aspect that we had both recognized, and that's about the number of security personnel on staff during late night events. Previously, it was 8 every time, but we had updated that to permit 1 for every 50 patrons. That is the only direct conflict to my knowledge, and that's a conflict that we had addressed during negotiations, and that is clear. There are no other conflicts, especially in the terms that I'm concerned about that the district has flagged. There's no conflicts there. These are things that can simply be added and would not change any of their obligations because those terms are from a board order that applies to the licensee regardless of later board orders.
Okay, and I think the chair pointed out at the beginning that we're not involved in negotiations of these. We just have to look at what does the wording say and what law applies. So, but thank you for that clarification.
All right. Mr. Mixon, I mean, do the parties have access to the transcript?
From the
For-
prior hearing?
Yes.
Yes, I
The
have it
hearing that
presented.
regarding this offer and compromise.
Yes, I
And
can present it.
because Mr. Mixon, if you have that, to go back to page 28, and I think it, Board Member Quinn had some concerns. And she had asked you, she had asked for clarification, and because I think there were some issues regarding your client's interpretation of what the offer and compromise, because clearly, even during the hearing, there were misunderstanding of what the offer and compromise was, at least by your clients. And there was some representation that you had put on the record, Mr. Mixon, in the transcript. If you have the transcript, if you look at page line starting, well, I guess line 2, where Ms. Quinn had asked a question, and then your response and the government's response on page 28. So if you have that, maybe you can review that to see if that changes if you have a different position today than what was stated at the day of the hearing. But I think one of the questions, what is it that Mr. Mixon, I think part of the issue is like, let's see. Should the board vacate the offer and compromise since there is disagreement regarding the parties? I mean, what is it that you want the board to do, Mr. Mixon? I mean, the government objects to the offer, to the security plan that was provided because they're saying that it is not, it's not consistent with the offer and compromise. The government's position is that, okay, fine, you have 15 days to comply, and to give you 15 days to comply. And if you don't comply within 15 days, I guess my assumption is that we would have a show cause hearing because you're not in compliance with a board order. So there are provisions there, or what is it that you're asking the board to do today? Vacate. Yeah, what is it you're asking the board to do? Because as stated before, we're not going to interpret what the parties' understanding of the offer and compromise is. The parties have to tell us what the offer and compromise is, because we can't interpret what was meant. So the government is saying that our interpretation of the offer and compromise is not consistent with your interpretation. And so the government is saying to us today is that because it's not in compliance, there's a provision of the law 25836D that says you have 15 days to be in compliance. If you don't comply in 15 days, then I guess we go to a show cause hearing. So we can either do that, or we could just void the offer and compromise. Void the offer and compromise and reinstate the summer suspension hearing, the summer suspension. And therefore that says that the establishment would be closed immediately. And then we have to go back to a hearing and schedule a hearing. So what is it that you're asking? what's your suggestion to the board of the way that we should move forward as option?
The primary request applicant is made, or rather licensee is making, is that the board look at the construction, what is written in the 2026 offer and compromise, and the requirements under 25-836, specifically subsection F, which provide for the amendment or replacement of security plans with new security plans, and conclude that licensee has performed its obligations under this
But
offer
no,
and
no,
compromise.
but the board can't do that. You're asking the board. I can't go on the terms. I cannot. You have to tell me what the terms are. The board cannot look at, as you know, and one of the things I've always told our board members when we have offer and compromise, we can ask questions, but we cannot negotiate with the parties. The parties have to tell us what the offer and compromise is, and we accept it or we reject it. So I can't look into I can't look into the offer and compromise. The parties have to say to me, this is what the offer and compromise is. This is what it says. And so therefore you're either in compliance or you're not in compliance. I can't go beyond that. I don't think the board has authority to interpret what we were not part of the negotiation. So I can't interpret what the parties meant. The parties have to tell us. So there's a fundamental disagreement between yourself and the government about what the offer and compromise provides. You need to tell us what is it the board and what action should the board take? Because I cannot go beyond. I can't interpret it. The board cannot interpret what the parties meant. Okay, so.
Understood, Mr. Chair. And it's not a request that the board negotiate with the parties and interpret our intentions or the mindset or anything like that. It's a statutory question. It's that 836F, as we read it, plainly calls for the replacement of security plans with new security plans, provided they're compliant with that section 836. We think under that review that it's clear that the licensee performed its responsibilities. But if in the alternative the board disagrees, we'd ask that you implement the show cause charges consistent with 25-836A as provided by the 2026 offer and compromise, and not to revoke the offer and compromise, which successfully met the objectives of all parties to the summary action, which was implementing new security procedures that would better equip the licensee with the security capabilities to prevent actions or conduct that gave rise to the summary action in the first place. That has successfully been achieved. The business has been reopened. It's retrained its employees, and it is better. It is a more effective operation at performing necessary security functions today than it was then. The offer and compromise worked. The district was in agreement with those terms. In fact, they proposed them. So there would be no need to roll back the clock and reset the summary action. If the board finds that we've not performed our responsibilities, it can order those show cause charges, and the licensee would quickly come into compliance with the 836D notice and implement additional terms. But I think that it is eminently clear that 836F does not provide for old security plan terms to remain in effect once the plan has been amended or replaced. And in fact, if the district's interpretation were allowed to prevail today, this would effectively result in no security plans ever being amended. That if the nature of the business changed, if the nature of its security needs changed, that the licensee would be locked forever into outdated terms that did not adequately address its security needs. And it seems to be very clear under 836F that amendment is something that the council wanted and wanted to happen at will, especially when a new security plan is ordered that is more catered to the specific security needs of the business at a particular moment in time.
All right. I mean, going back to the transcript, I mean, you specifically respect to the definition of private event that was provided, that was basically you stated that you understand it's incorporated into the security plan that they have to abide by now. Because I think there was some misunderstanding about, I think you was clarifying what is it that your client stated, because I think your client was stating that I guess they didn't have to abide by the 24 board order. And I think that predated this new owner, and I think you clarified that it was incorporated into this new security plan. So as I said before, the part you have to, what the government, rather than going to a show cause, they're relying on a provision of the law that says, okay, we give you 15 days to be in compliance. So, and if you don't comply within 15 days, I will go to show cause. So is that something that's acceptable to you, that, I mean, you guys can figure out and be in compliance with 15 days, or is it that, do we need to go back to a show cause hearing, in the sense that we're gonna make recommendations and go through that much more elongated procedure of having a show cause? I'm in the sense of providing the notice, have a status hearing and have a show cause hearing, or just like, the government says it's not you're not in compliance, and so therefore you have 15 days to comply, you're going to comply. I mean, the board, I don't know what the board's going to do, but I guess I'm asking just for you to provide some direction based on the government's position.
If the board agrees with the interpretation put forth by the government, then licensee would have no problem coming into compliance in that time frame. If that is the board's determination. But I mean, again, we believe that the statute and the offer are clear, and both of those conditions that the licensee is subject to are satisfied. We'd ask the board find that those are satisfied, but the licensee would have no problem complying with the board's order, should it order in favor of the government.
Well,
Mr. Chair, may I just clarify a point?
yeah, go ahead, ma'am.
So Mr. Mixon indicated that the district's belief was that the compliance issue is purely about the 2026 OIC, and that is not the issue. The issue is they are not in compliance with the 2024 OIC, and that board order that converted the OIC into a board order that the board has said applies. That code provision 836D refers to requirements on file with the board. That encompasses all of the board orders to this licensee, which means the 2024 OIC. All of the discussion we've had about what the parties thought about the 2026 OIC and the representations that Mr. Mixon made was just to illustrate the fact that that 2024 OIC is still part of the board's record and the requirements for their security plan. So in that sense, 836D is absolutely the right direction to go if we want to get this done quickly, and if they will agree to make the changes to incorporate the 2024 terms. If not, then we'd happily go to show cause, but I think 15 days and risk of a suspension is a much quicker and more effective path forward.
I'll give you the last word, Mr. Mixon. Because we have to make a decision, but as I stated it before, it's either if the government is saying that you're not in compliance, your client is not in compliance with the offer and compromise, then the board is in no position to review the offer and compromise and state what it is that the intent of the parties were. It's either the parties have to tell us what their intent, what was the intent, the parties have to share with the board what the offer is. What is it that the offer in compromise stated? I mean, it's the first time I've had this. I've had this hearing in the sense that we had we have a summary suspension here, and here's an offer in compromise, and there's disagreement between the parties about what is it that was required. And so yeah, so I'll give you the last word, what it is that what's your recommendation to the board, and we'll figure out where we go from there.
Well, as a first matter, the licensee would ask that the board find that 25-836F is the operative provision here, which provides for the replacement of security plans, and that such a security plan compliant with 836 has been satisfied. In the alternative, the licensee doesn't disagree that the board has the power to order the amendment of a security plan to be fully compliant, and the licensee would promptly comply with such a written notice if it's provided, but that no one's interest is served by vacating the prior offer in compromise, which was the intentions of the parties to resolve the summary action in a manner that fully addressed the conduct that led to a summary action being imposed. That's been satisfied. The licensee has taken on aggressive, rigorous additional security measures, and will continue to do so. And if the board feels that the further they need additional terms subject to that prior security plan, which of course has been replaced and amended, but if that is what the board finds, then licensee will come into compliance with that. Although we proffer that 836F should direct the board to approve the security plan that's already before them.
No, I said I was going to give you the final word, Mr. Mixon. I can't give you the final word. I have to give the government the final word because they're the one who brought this matter before us. So the government had the last word. I apologize.
Thank you, Mr. Chair. The government's position is that the recently submitted 2026 security plan is not in compliance with the requirements on file with this board, which are the 2024 board order approving the 2024 OIC and the 2026 board order approving the 2026 OIC. Of course, we haven't noted any failings in the language of the security plan with respect to the 2026 OIC. Our primary concern are terms from 2024. And we agree it's in everybody's best interest to have licensee make those amendments, add those terms back in and resubmit rather than draw this out through a show cause. And they have had ample time to do this. We have noted this issue, and they noted it themselves to the board on April 22nd when they said the 2024 terms still apply. And again, throughout May and early June, this was raised to their council and no changes were made. It's fine if they're going to have another 15 days, but this has been an ongoing denial of their obligation under a clear board order. Thank you.
All right, thank you. All right. I've been spending. I need to bring this matter to closure, and I'm looking for my new script to close this matter, so I apologize. Let me have this placed in your script that I have to read, so give me a minute, please. Give me 1 minute, please. I have too much paper in front of me, so hold on, please. Okay. All right. All right. I'll find the case. I apologize. All right. As chairperson of the Alcoholic Beverage and Cannabis Board, in accordance with DC Official Code Section 2-575 of the Open Meetings Act, I move that ABC Board hold a closed meeting for the purpose of seeking legal advice from our counsel on case number, I don't have the case number, but this is, there's no case number, but this is Kick Act Throw Social DC license number 133556. Pursuant to DC Official Code Section 2-575B4A of the Open Meetings Act and deliberating upon Kick Act Throw Social DC license number 133556 for the reasons cited in DC Official Code Section 2-575B13. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll now have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Turner, agree.
And Mr. Anderson, I agree. The matter passed 6-0. The board will take this matter under advisement, and we will issue a decision accordingly. Thank you very much for your presentation today. Thanks.
Thank you.
All right.
Thank you.
You're welcome. All right. Bye-bye. All right, the next matter on our calendar, it's a fact finding. It's Barleaf Holdings, license number 126758. Mr. Oriana, can you please elevate the rights of the parties in this case?
Good thing. Cameron Mixon. Access elevated. Alex Haji, access elevated. Robbie Martin, access elevated. And that appears to be all term.
Do you need a minute, Mr. Mixon?
No, Mr. Chair, I'm ready.
I know that you're switching gears, but if you're ready, you're fine. Okay. All right. Let me have Mr. Mixon, can you please identify yourself for the record?
Cameron Mixon, counsel for the applicant, CAMERON
And I see there are two individuals on the line, so can they please spell and state their name for the record and their relationship to this establishment?
Yes, sir. My name is Alex Hodge. I am the applicant representative on the license. My name is spelled ALEX, last name HAJE.
Now you said I'm sorry, what is your role, sir?
I'm sorry, I'm one of the listed owners on the license, sir.
All right, okay. Mr. Martin, please spell and say your name for the record.
Good afternoon, Board and Chairperson Anderson. My name is Robbie Martin, and I am the General Manager of the applicant's retail operation, which is Higher Ground Cannabis Dispensary. My name is Robbie Martin.
Good morning, sir. All right, this is a fact finding. I know that we recently had a hearing on this establishment, but it's BioLeaf Holdings LLC applied for medical cannabis cultivation center tier 2 license. The proposed location is 1135 Oakey Street Northeast. The business is ready to open and pass final inspection. It's my understanding there's a medical cannabis retailer co-located at the premises. So, all right. So I guess one of the questions I need to ask Mr. Mixon, because there's a specific regulation regarding co-locations, 22-C DCMR section 5614. That states 14.1 that states nothing in this title shall preclude two or more cultivation centers from locating in the same building, provided they maintain A, separate books and records, and B, their own secure and distinct registered premises that is separate at a minimum by the fixed boundary. And you have 5614.2 that talks specifically about separately licensed medical cannabis businesses may be located in the same building or space, but shall maintain separate books and records and a separate secure space. A medical cannabis business, or this is for business, but I think in this particular case, a cultivation center. So I mean, how familiar is your client, and either yourself or one of your client can share with us how familiar are they with this provision?
We certainly have discussed it, and it was part of their plans at the outset of the two different, well, I guess rather the second license phase, application phase, when they applied for a retailer, which followed their application for the cultivation center at this building. I know that the applicant has sought distinct certificates of occupancy for the spaces. And that they do, in fact, maintain separate secure spaces. There is a retailer side, there is a cultivation side.
Is it the I guess just educate me, is it the same ownership, or is it separate? They're separate ownership?
I can answer that if you'd like me to jump in.
You can, yeah. I just identify yourself for the record, sir.
Yes, sir. Alex Hodge, one of the license holders. We have varied members, obviously a cultivation business of this investment. We had to seek investment, obviously, it's a very large fit out. We've invested heavily into the industry, so we have some similar owners, but different ownerships. It's not all the same, if that helps.
All right, so regarding this license and regarding this is a manufacturer tier
cultivation center.
I'm sorry, the cultivation center tier 2 license. So tell me, what is it that what's a cultivation center tier 2 license? Be specific. What is it that you're doing?
Yes, sir. We've built a very state-of-the-art cultivation facility with full environmental and irrigation controls. We've invested heavily into the industry, and we've ensured that everything is compliance facing forward. That's one of our top priorities. We've made sure that's our top priority with our retail business that's been operating since the beginning of this year. Not only have we ensured that compliance is a priority for ABCA, we've also made the additional step to apply with the DEA and be ensured that we are compliant with the federal framework as well that is forthcoming. We plan on doing the same thing with the cultivation facility. Since the initial onset of the fit out of this property, we've been developing that space with GMP, or good manufacturing practice standards, in mind, so that we can be at the top tier of facilities around the country that are working towards a federal framework of compliance as well as a local regulatory framework of compliance. So those are very important to us and our businesses.
So because you have a tier 2 license, what is it your license? If we were to, you've passed inspection, so this is the last stage. But what is it that you're licensed to do, please?
Yes, sir. We are licensed to cultivate cannabis. With, I believe, the tier 2 allows us to go over the 10,000 square foot of flowering canopy. It says 10,000 to 25,000 square feet, sir.
I think Mr. Martin wants to say something. I see that if you want to unmute yourself, sir, and you can speak. If Mr. Mixon said that's fine.
Yes, of course.
You were
I
saying
was
something.
making mental notes to confirm what Alex was saying in my head, which was the tier 2 license enables cultivation between 10 and 25,000 square feet.
All right. So tell me, tell me your intended operation. So it's a cultivation center. So tell me, I don't know what that means. So what is it you're going to do?
Yes, sir. We are going to be growing cannabis at the highest level to distribute to the retail stores within the District of Columbia. It will have to be tested through the testing lab, and then once it's cleared and approved, then it can be distributed to the retail dispensaries within the city.
So what experience your team, who has experience as a grower? Provide us some information regarding your experience as a grower.
Yes, sir. My experience personally has been in DC as a business owner in the alcohol business and nightlife, particularly for almost 15 years. We were very active when the DC Council and the mayor set up the Office of Nightlife and Culture with Sean Townsend taking the helm. We worked closely with that office when COVID hit. I in particular worked closely with Mr. Townsend to help support the council and the mayor at that time to secure funding for all of the nightclubs, bars, and lounges that we knew were going to be shut down for an extended period of time. Our efforts in that eventually became the DC Micro Grant Program. So we've been involved, heavily trying to be a part of this business community for a long time. I personally have made the transition into the cannabis space and out of the alcohol sector of the community. I've learned a lot about this over the past 3 years. I've invested heavily into it. Our grower in particular, to answer your question, has been a part of a compliant multi-state operation for many years. He knows very much as to what it means to make sure that not only is our product up to standards, but that we're meeting all of the laws and regulations that apply as well to that process.
So you said that your grower is from multi-state. So just it's not catch you. I mean, I just can't decide that, okay, I want to go grow cannabis. So I mean, it's like I have visited some in this capacity. I've visited some cultivation centers. So I mean, it's like I see that's very elaborate. So you've told me that you're an alcohol, but I mean, I know you don't make your own moonshine. So
Yeah, I do not.
in the old days, you would talk about moonshine. People would make moonshine, which so yeah, but still, so that's what I'm asking. I mean, tell me what tell me about the growing. I mean, I just can't decide I'm going to start growing.
No, it's okay.
And this is a huge establishment. So tell us some more information about the experience in growing. Who is it that? Yeah.
Of course. So our partner, he's a good partner as well as our grower. He's not just an employee. He will be a partner as well. And we listed with the revised operating agreement. Once the license is approved, will be submitted to the board. But he started in Colorado as a caregiver. He went to New England and worked with a company called Ethos for a long time as a grower there. He came back and worked in Virginia for Jushi, which is a Beyond Hello medical dispensaries that you see around Northern Virginia for a period of time as well. And then he went international to Thailand and had a operation there when they applied legal framework as well to cannabis. He's returned to Washington, D.C. to be a part of this business with us. and we're very excited to do what we're about to do.
All right. All right. So just for the record, just describe the layout of the premises with the co-located retailer, please.
Yes, sir. My pleasure. So basically, we have Unit A, which is higher ground. You have a retail dispensary with a safe use treatment area as well. We have a summer garden, one of the, I believe, the only one in the city currently. That's the Unit A space, which is the, let's say, about 2,500 square feet on the front side of the building on the first floor. And then secondary on the remaining space of the building is the cultivation facility. So they are delineated, separate certificate of occupancies, full security cameras for all purposes of necessity, but truly one of the most unique spaces in the city. We actually would love to invite any of the board members to come see our facility and what we've invested into it. We believe that this concept that we're putting forward is truly a culmination of ABCA's efforts to create this industry and move from the I-71 phase into a regulated market. And we love what we're doing. We're very happy with it.
So how many, I know Mr. Martin, as general manager, has introduced himself as an employee. I mean, how many folks do you intend to employ?
Currently on the retail side, I think we've got about 7 to 9 employees, but in varying shifts. For the cultivation side, anywhere from probably about 13 to 25. We'll see once we get going what the demand is going to be, but that's what we're looking at.
So what other positions do you seek to fill?
I'm sorry, sir?
What are the positions that you seek to fill?
Of course. I mean, on the cultivation side, you're going to have everywhere from flower techs to flower managers. You're going to have post-harvest techs, post-harvest management. You're going to have a general repair person that goes around and fixes dehumidifiers and HVAC. I mean, we've invested, again, heavily into that side of the business. So there's a lot of mechanical portions to this. There's a lot of high-end environmental controls and irrigation controls that go into that side of the business. So you'll have varying staff of, people that are helping care for the plants, defoliate them when the time comes, move them from a nursery type of situation where you have your mother in your veg room into flowering rooms where they'll finish the life cycle of the plant until they're ready for harvest. So there'll be varying employees that are working throughout that process, sir.
No, I know Mr. Martin has been introduced as a general manager. So has Mr. Martin or any other employee been trained to use Metric?
Yes, sir.
What about you? Have you been trained to use Metric as an owner?
I have. I've completed certification as well. Yes, sir.
I would also offer up, Chairman.
Go ahead, Mr. Martin.
Sorry, getting our audio situated. I'll also offer up that we've brought in another experienced operator from California and Oregon's markets to act as. So I run the management for the retail and hospitality and consumption spaces. So very familiar with Metric, have been working in it for many months now. This is the second store I've helped open. I'm also the president of the DC Cannabis Business Association, so try to stay very plugged into any legislative changes. But to Alex's point earlier, compliance is our number one priority. We've passed, I believe, 2 ABCA drop-in inspections so far, with either no violations being found on either. Just checked our inventory system, and we're showing 0 discrepancies in both the city's seed-to-sale system Metric as well as our point-of-sale system Flow Hub. And we're aiming to bring that same level of diligence and compliance to the cultivation side of the house.
I know you have passed final inspections. If this board was to greenlight the issuance of this license, when is it that you'd be able to operate? What's the
Not sure if the
walk me through
question's posed either.
Right.
You want me to take this, Alex? Or?
Yes.
Sure. So really the imminent, Chairman, the retail side of the house.
Please mute your line, sir. I think there's feedback.
I muted.
Go ahead.
The retail has been operating for a few months now. The cultivation is really kind of phase 3
No,
after the first.
you have not muted your
Maybe
line.
you need
Your
to
line,
mute
Mr.
Alex.
Hawkins. You need to.
Oh, I'm sorry. I need to mute a microphone. I'm just going to go in another room. I apologize, gentlemen.
Oh, you're in the same location. That's why we're getting the feedback.
Yeah, we're switching rooms. I'm at work. We just opened the store at noon, so making sure the staff got everything opened. The facility really came online in phases, with the retail coming online earlier this year, with the areas that followed. Phase 3 from the cultivation perspective has really been trouble testing all of the systems that Alex mentioned, the HVAC, the fertigation systems, the lighting, all of those environmental controls that go into and have been certified by the city. What's next for us is really to start cultivating. And so there's a few different ways that you kind of kick off a facility, but the first one is generally to select your genetics. That's kind of the phase where we're at now for the different types of products that we'll be bringing to the market. But really, sir, as soon as this license is issued, the facility is poised to be turned on and start operating.
All right, so and this is for you, either you can respond, Mr. Mixner or Mr. Hache. Does the business understand that you must maintain a separate secure space, maintain separate inventory records and financial accounts for the co-located medical cannabis retailer?
Yes, sir, we do.
How will you ensure inventory records, financial accounts will remain separate?
We have separate accounting for everything. I mean, all transactional billing, invoicing, everything is 100% separate. We have an accountant to manage all those books. We have internal compliance and inventory manager that will also be ensuring that all product is managed accordingly through metric for the seed to sale tracking system. Like I said, as we grow this, we are looking at developing systems that have RFID chips to make sure that everything is tracked, like to the T.
And because this is not my first time at the rodeo, and you've spoken about, you're working with Oregon, California. Does the ownership understand that it can only distribute, store, and sell medical cannabis products provided by DC licensed cultivation centers and manufacturers?
Yes, sir,
Yeah.
Absolutely. We
I'll double down on that and commit that you will have zero issue with our company whenever it comes to cannabis inventory compliance. And I understand there's been a few cultivation centers that have come and gone pretty quickly, and I commit that we will never be on that list, Chairperson.
I'll never say never, but it's your intent that the James Bond never say never, because he said never and he came back. So it is your intent to comply with the law, and that
that's correct.
You don't intend to appear in front of the board, but we can't be that absolute. So that's why I said never say never, but it's your intent to be in compliance with the law. I'll accept that. Thank you.
Yeah,
all right.
Absolutely.
Let me see. Does the business, and I'm talking specifically about the cultivation center, does the business currently have any Schedule I substance in its possession, either on site or another location?
No, sir.
Does the business have any non-medical cannabis products in its possession, either on site or another location?
No, sir.
Does the business understand that the presence or distribution of Schedule I or non-medical cannabis products may lead to the closure of the business or the revocation of the license?
Yes, sir.
Any questions by the board members? All right. Any final comments you want to make before I bring closure to this hearing?
I would just want to thank you all for your time. And again, we very much would welcome any visits. If any board members would appreciate a visit, we'd love to tour you and show you the facility. We do truly believe that ABCA has made a very good effort to convert and create this legal framework. And we're proud of what we've done here. So if anybody ever wants to come by, we're happy to have you.
Well, it's not, we just can't come by as that. It has to be scheduled, but at some point, the board will be visiting these new establishments to see what it is that. So do not be surprised if at some point, probably in the fall, that a request is made for the board to tour the facility if we decide to give this green light. Thank you very much for for being here today. The board will take this matter under advisement, and I believe that the sense of this board is that we'll approve the license because, yeah, the board will approve it because I'm about to do the licensing agenda, and your establishment is on our licensing agenda. So just stay tuned, and stay tuned. Once I do the agenda, then you'll hear whatever decision that the board makes regarding whether or not we're going to approve the issuance of this license. Okay.
Yes, sir.
All right.
Thanks, sir.
Thank you very much for your presentation today. Have a great day.
Thank you, Mr. Chair.
All right. Thank you. All right. Let's see. And that is the end of our calendar item for this morning. And so now let us do our agenda item for the morning. Okay. So the first agenda item that I will do today, it's our legal agenda alcohol. And on the legal agenda alcohol, there are 4 matters. I'm going to review all 4 in the record. Then I'll make a motion and ask for a second, and then ask that the board members vote to approve the recommendation that's put forth by the chair. So number 1, review of an offer in compromise. This is in case number 26-251-00008, 12 after 12, license number 117238. The offer in compromise for that case is as follows. Charge 1, failed to follow security plan, statutory authority, DC Code Section 25-823A6. There's a fine of $4,000 paid within 60 days, or the license shall be suspended indefinitely until the fine has been paid. Charge 2, failed to maintain footage of a crime involving a gun for at least 30 days, statutory authority, DC Code Section 25-836G2. Fine, there's a fine of $4,000 paid within 60 days, or the license shall be suspended indefinitely until the fine has been paid. The recommendation will be approval. Number 2, review of an offer in compromise. This is for case number 26-251-00009, 12 after 12, license number 117238. The offer in compromise for this case is as follows. Charge 1, failed to follow security plan, statutory authority, DC Code Section 25-823A6. Fine, there's a fine of $4,000 payable within 60 days, or the license shall be suspended indefinitely until the fine has been paid. Charge 2, allow the establishment to be used for unlawful purpose, statutory authority, DC Code Section 25-823A2. There's a fine of $4,000 paid within 60 days, or the license shall be suspended indefinitely until the fine has been paid. The recommendation for that one will be approval. Number 3, review of an offer in compromise. This is in case number 26-251-00018, the HARP, license number 133946. The offer in compromise is as follows. Charge 1, increase occupancy without board approval, statutory authority, DC Code Section 25-762A(b)(1). There's a $1,000 fine to be paid within 30 days, or the license shall be suspended indefinitely until the fine has been paid. Charge 2, provided music or entertainment without board approval, statutory authority, DC Code Section 25-762A and B8. There is a fine of $1,000 to be paid within 30 days, or the license shall be suspended indefinitely until the fine has been paid, and the recommendation will be approval. And number 4, review of Emeritus Condominium. This is it. This is Philip Chow Merchants Marine, license number 121216. This is the recommendation. This is a FYI for the board. I therefore make a motion that ABC board members vote to approve the recommendations put forth by the chair for the legal agenda alcohol. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner,
Mr. Turner, agree.
and Mr. Anderson, I agree. The matter passed 6-0. Right. Okay, the next agenda we're gonna read, it's our legal agenda alcohol addendum. And in this, on the addendum, there is one case. It is case number 26 CMP 00017. It's Hamilton Hotel DC, license number 107636. The offer and compromise for this case is as follows. Charge one, failed to file quarterly statement. Statutory authority, DC Code Section 25-113BA, small a, large A. There is a fine of $2,000 payable within 30 days, or the license shall be suspended indefinitely until the fine has been paid. Other terms, the licenses shall be suspended for 1 day, which shall be stayed for 1 year, must present pending quarterly statements that have not been submitted as yet. I therefore make a motion that the offer in compromise be accepted. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, a second. The motion, we have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Turner, I agree.
Mr. Anderson, I agree. The matter passed 6-0. We now move to our legal agenda, medical cannabis. There is one matter on this agenda. Review of requests for hearing. This is case number 26 CC 00017. Mirage, license number 129298. The recommendation is that the board will approve that, however, the board will stay this matter pending completion of the related enforcement action. I make a motion that we that is a recommendation by the board. Is there a second?
Mr. Jones, I second the motion.
Mr. Jones, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I will agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Mr. Turner, I agree.
And Mr. Anderson, I agree. The matter passes 6-0. Okay, so let's now go to our licensing agendas. All right. All right, so let's now do our first licensing agenda is the alcohol agenda. Alcohol licensing agenda. On this agenda, there are 5 matters. I will review, make recommendation. At the end, I'll ask the ABC board members to vote to approve the recommendations put forth by the chair. So number 1, review application for stipulated license with letter of ANC support for new ABC license. This is for Ma Yanis, Tex-Mex and Bar, license number 136462. Recommendation approval. Number 2, review application for entertainment endorsement to provide live entertainment inside of the premise and outside in Summer Garden. This is for Wake Me Shake me, license number 125480, recommendation placard. Number 3, review application for sidewalk cafe endorsement with 8 seats. This is for Mary Pin, license number 127357, recommendation placard. Number 4, review application for sidewalk cafe endorsement with 8 seats. This is for Provost, license number 108015, recommendation placard. Number 5, review application for Summer Garden endorsement with 30 seats. Lupo Osteria, license number 101833, recommendation placard. And so therefore I make a motion that ABC board members vote to approve the recommendation as put forth by the chair for the alcohol licensing agenda. Is there a second?
Mr. Turner, I second.
Mr. Turner, second the motion. We have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Turner, agree.
Mr. Anderson, I agree. The matter passed 6-0. We now move to the supplemental licensing, alcohol licensing agenda. On this agenda, there are 5 matters. I will review all 5, make recommendations, then I'll make a motion, which I will ask to be second to approve recommendation as put forth by the chair. So number 1, review application for stipulated license with letter of ANC support for a new license. This is for L District 24, license number 136460. Recommendation approval. Number 2, review application for stipulated license with letter of ANC support for a new license. This is for Wild East Club, license number 136372, recommendation approval. Number 3, review application for second Summer Garden endorsement with 112 seats. This is for Provost, license number 108015, recommendation placard. Number 4, review request for off-premise storage permit endorsement to store alcoholic beverages off-site at 301 New York Avenue Northeast. This is for, this has been requested by 3800 13th Street, retailer a liquor store license number 19410, recommendation approval. Number 5, review request to allow Fraiche, Fraiche LLC to serve as corporate paymaster for alcoholic beverage purchase from wholesalers and manufacturers. So the request is being made by Fraiche, Fraiche, license number 115577, recommendation approval. I therefore make a motion that ABC board members vote to approve the recommendation as put forth by the chair for the alcohol licensing supplemental agenda. Is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Mr. Turner, agree.
And Mr. Anderson, I agree. The matter passed 6-0. We now move to our second supplemental alcohol licensing agenda. There is one matter on this agenda, review of the architectural floor plan for a new Class B full-service grocery store. This is Street Markets, the license number to be determined. The recommendation is to placard. I therefore make a motion that ABC board member vote to approve this matter. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. And the motion is to approve the recommendation to placard. Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
And Mr. Anderson, I agree. Mr. Turner.
I agree.
And Mr. Anderson, I agree. The matter passed 6-0. And so let's now move to the board's temporary one-day and substantial change docket. And let me just say, there are just 9, so let me review all 9 in the record. So the first one is John Munier, Munayer, one-day license class G. This is for the St. George Middle Eastern Festival fundraiser. This is August 15th. The license number is 136765, 150 attendees, 3 security guards, recommendation approval. Number 2, a request from Daniel Daly, one-day license class G, Oak Room soft opening. This is July 24th through July 27th. The license number is 136809, 200 attendees, 4 security guards, recommendation approval. Number 3, a request from Jonathan Ruby, one-day license class G. This is for a drag show. The dates are July 24th through July 25th. The license number 136747, 419 attendees, 8 security guards. The recommendation is approval. However, it's approval pending future approval from the Department of Buildings. Number 4, a request from Samba Patek, Pathak. This is for Festival License Class H. It's it's an event, a theoretical Woody Gertrude American song performance. The dates are August 6th, 7th, 8th, 9th, 13th, 14th, 15th, 16th, 20th, 21st, 22nd, 23rd, 27th, 28th, 29. The license number is 136773, 100 attendees, 2 security guards, recommendation approval. The next matters are retroactive approvals. The request is from Yessica, Yessika, Chica, Chicas, one-day license class F. This is for the Quinceanera celebration, Quincenera. The event was July 18th. The license number is 136774, 300 attendees, 6 security guards. The recommendation, retroactive approval. Number 6, a request from Katie Kirkpatrick, Kirkpatrick, a one-day license class G fundraiser. The event was July 18th. The license number is 136790, 100 attendees, 2 security guards. Recommendation, retroactive approval. Number 7, a request from Juan Dracos, Dracoulis, for one-day license class G. This is for tasting. This event was yesterday, July 21st. The license number is 136813, 41 attendees, no security guards. Recommendation, retroactive approval. Number 8, a request from Birhane, Birhane, Tesgaye, Tesgaye, one-day license class G, graduation, that was July 18th. The license number is 136777, 100 attendees, 4 security guards, recommendation approval. And number 9, a request from Daniel Daly for one-day license class G, Oak Room soft opening. This is July 20th through July 23rd. The license number is 136768, 200 attendees, 4 security guards, recommendation approval. I therefore make a motion that ABC board members vote to approve the recommendations put forth by the chair for the board's temporary and one-day substantial date docket. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Turner, agree.
And Mr. Anderson, I agree. The matter passes 6-0. We now move to the board's alcohol license administrative docket as published for July 22nd. And on this docket, there are 7 applications, and without objection, I make a motion that ABC board member vote to approve the applications on this docket. Is there a second?
Mr. Meadows, I second.
Mr. Meadows, I second the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Jones, I agree.
Mr. Turner,
Mr. Turner, agree.
and Mr. Anderson, I agree. The matter passed 6-0. We now move to the medical cannabis licensing agenda. There is one matter on this agenda, requests of product and labeling. This is for Pink Box, license number 126422. I make a motion that we approve this request. Is there a second?
Mr. Jones, I second.
Mr. Jones has seconded the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Turner,
Turner, agree.
Mr. Anderson, I agree. The matter passes 6-0. And our final agenda for the morning calendar is a medical cannabis licensing administrative docket. So I make a motion without objection that the board votes to approve the medical cannabis license administrative docket as published for July 22nd, 2026. The docket has two applications. So without objection, I make a motion that we approve those applications. Is there a second?
Mr. Turner, second.
Mr. Turner, second the motion. We'll have a roll call vote. Mr. Grant,
Mr. Grant, I agree.
Ms. Quinn,
Ms. Quinn, I agree.
Mr. Meadows,
Mr. Meadows, I agree.
Mr. Jones,
Mr. Jones, I agree.
Mr. Turner,
Turner, agree.
Mr. Anderson, I agree. The matter passes 6-0. We're now at the end of our morning calendar, and so the board is going to go in recess. What I will suggest is that the board, it's 12:55, that the board goes in recess until, so the board we're not going to go to executive currently. I'm asking that the board go to lunch, and that the board return to executive session at 1:25, that the board goes into executive session. The board return to executive session at 1:25, and the board will come back to the public session at 1:40. So we will come back to the public session at 1:40, and I'll ask the board members to return to executive session at 1:25. Have a good lunch. I will see you in executive session at 1:25, and I'll see the public at 1:40. Thank you. Good afternoon. We're on the record. Good afternoon, everyone, and welcome to the afternoon session of the ABC Board. My name is Donovan Anderson. I'm chairperson of the board. Joining me this afternoon are 6 other board members. You have Mr. Silas Grant, Ms. Terry Janine Quinn, Mr. David Meadows, Mr. Ryan Jones, and Mr. James Turner. The board has 6 members in attendance for the conduct of business today, and that constitutes a quorum. This afternoon, we have one case, and so I will quickly, we have a protest case. I'll quickly call the case. Case number 26 PRO 00046, East of the River Liquors, license number 130506. This is an application for a new license. Good afternoon, Mr. Oriana. Can you please elevate the rights of the parties in this case?
Good afternoon. Cameron Mixon, access elevated. Frederica Kramer, access elevated. Anthony Chase, access elevated. Romero Smith, access elevated. Todd Evans, access elevated. And there's still a couple more people, but I'll wait to see to call if we need to call them. That's it, Chairman.
Okay, thank you. Give me 1 minute, please.
Investigator Tavro Prout, access elevated. That is all, Chairman.
All right, thank you, sir. Just give me 1 minute, please. Oh, no, I don't have this. All right. So let me have everyone introduce themselves. Let's start with you, Mr. Mixon.
Yes, Cameron Mixon, counsel for the applicant, CAMERONMIXON.
Who's the applicant, Mr. Mixon?
Mr. Romero Smith.
Mr. Romero Smith, can you come on camera, please, and please identify yourself for the record?
How you doing? My name is Romero Smith, and I'm the applicant.
Are you able to come on camera, sir?
Yes, sir. One second. All right. Trying to figure it out.
No, I can't see you.
If you press start video, is that an option?
You said start video?
Yeah.
Yeah, I don't see that. I just see
Okay.
unmute.
Did you join via the web browser?
I Cameron sent it to me in a link, so I just joined it.
Through a computer or a phone?
No, it's on my phone.
Okay. Maybe if you exit out and rejoin, you may see some approval options for camera. But I'll let the chairman decide.
Why don't you do that, sir? I mean, it's an application for your license. I want to see who I'm, if possible, I want to see
So
who
you want me
it is.
to hang up and then join back on?
Yes, try that.
Okay.
lovely weather we're having.
What do you say, Mr. Mixon?
Just acknowledging what a beautiful day it is.
It is?
In my opinion, at least.
I'm trapped inside, Mr. Mixon. So I don't know what the day is. I mean, you're trapped inside as I do. I see your beautiful background, so I guess that's why it's a beautiful day for you. You have that beautiful background behind you. I mean, I just have a wall behind me, so I can't look back to see a beautiful day. I just see this wall. But I'm pulling your legs, Mr. Mixon. All right, is that
We can see you now.
all right, Mr. Smith, just take yourself off mute and please spell and state your name for the record, sir.
How you doing? My name is Romero Smith, ROMERROSMITH, and I'm the applicant for East of the River Station.
Good afternoon, sir. Miss Kramer, can you please identify yourself for the record, please?
Yes, sir. Frederica Kramer, Fredrica Kramer. I am the ANC Commissioner for 6007.
And you are representing the ANC, you're representing
I'm
60.
representing and authorized to testify for the commission.
You're this is what I do for all ANCs, ma'am. You're here representing ANC 6D.
Correct. I am here representing ANC 6D. Absolutely.
And that's what I try to always remind the ANC that you're not representing your single member district, you're representing the ANC, because the ANC is given, if we're going to give great weight is given to the ANC as a body, not to a single member district. So that's why I want everyone to always state that I'm here representing the ANC. Okay, so I'm not picking on you, ma'am. I try to be very consistent with, and if you talk to your colleagues, I'm not picking on them. I just want to, because we have a lot of conversations about ANC says you need to give us great weight. So since you're saying you need to give great weight, I'm reminding the ANC, when you show up, you need to say, I'm here representing ANC, the ANC, not my single member district. And because we will only give great weight to the ANC and not a single member district, okay?
You are absolutely correct, and I would have done that, but not in the right time, so thank you.
That's fine, my man. I try to be consistent in our.
Excellent.
Now, this is a protest hearing for a new license. So, and I guess the bottom line, let me ask Ms. Kramer, from your perspective, what's the ANC's position? Is it that the ANC says that no, do not grant the license, or is it the ANC saying yes, you can grant the license, but we want to put some restrictions on the license? What is the ANC's position?
The ANC's position is to not accept the license unless it is with conditions. And I was going to give that detail in my opening statement. I thought you were going to call to ask me for
No,
that
I'm gonna.
statement.
Yeah, no, I'm gonna do that. I was just trying to find out if I know what the position of the party said. If the ANC's position was that we don't have a problem, you grant the license. However, these are then the board could say, okay, we're going to grant the license, and then we would have testimony and witnesses on whether or not we should propose any restrictions on the license.
Let me say it more clearly. We would deny the license. We would
okay.
Move to deny the license unless it had the conditions, at a minimum, the conditions that we've asked for.
All right, that's fine, ma'am. So we'll have the I'm trying to all right, that's fine. All right, so the how this hearing is going to operate today, we'll have opening statements by the applicant. Then we'll have we'll have opening statement. All right, I'm sorry. The board will call its first witness, which is Mr. Prout. So he will go through his report. The board then will ask questions of the witness. Once the board has asked questions of its witness, then the applicant will have an opportunity to ask questions, and the protestant will have an opportunity to ask questions. Once that's done, then the applicant will present its case. Once the applicant has presented its case by calling witnesses, then the protestants will present its case and call witnesses. So what I need the parties to declare, it's why is it that, at least from the applicant, why is it that the applicant believes that we should grant this license? If they should put testimony and witnesses on, why is it that we should grant this license and why you believe it's appropriate? And the ANC should, in their case in chief, they should provide testimony on why is it that they believe that this granting the license is not appropriate. And if the board was to grant the license, why is it that the ANC believes that we should impose conditions on the license, because this is a liquor, at least a liquor store, because it's a retailer A. All right, so what we will start then, Mr. Mixon, do you have any preliminary matters you need to bring to the attention of the board?
Yes. One initial preliminary matter is that applicant would move for the continuance of this protest hearing. The parties are currently engaged in settlement negotiations, and it's our understanding, based on the last representations, that both parties still intend to draft and file a settlement agreement. And not to get into any of the substance of the settlement negotiations, but purely to talk about process. The first draft of the settlement agreement was prepared on and proffered to applicant on Saturday of this week. And a responsive draft was sent back to the ANC, I believe, yesterday. We await feedback and commentary on that, but both parties seem to be in agreement that the license be approved, subject to whatever specific conditions, which can be worked out in the parties through the negotiation process. In fact, as of our last negotiation, it's my understanding the ANC position is that even if there were to be a hearing held today, that we would continue to discuss the substantive terms of a settlement agreement and file one to the board prior to the board's decision. For that reason, we think that it would not be necessary to hold a hearing today when the parties are still fully capable of resolving the issues between themselves.
Ms. Kramer, what is your position? You need to unmute yourself, ma'am.
Yes, thank you. Our position is that we do not feel that we are close to a settlement agreement because of a complicated situation that I will lay out as soon as I offer our opening summary of where we think we are. I don't think that it is realistic that we will be able to reach a settlement agreement based on the conditions that we've outlined and the status that we understand this application is in, which is actually preliminary to a further application for a Class C license. I'd like to explain all that. I mean, I know that I'll get the opportunity to explain all that, but given that, I don't think that simply delaying the protest will accomplish anything for the board or for our interests and the residents' interests.
I'm not the licensee. I mean, the burden's on the license. All right, because this is a new license. If the parties want to, if the licensee is asking to continue the hearing, I can continue the hearing because I can only continue the hearing with the consent of the licensee. But because it's a new license, we have to issue a decision within 75 days. If the licensee wants to continue the hearing, I mean, I'll be inclined to do that because that is at their own peril. So
To clarify, Mr. Chair, the licensee does not have an imminent opening date scheduled in the near future. So to extend the protest process to allow for further settlement negotiations would not prejudice us in terms of our ability to obtain the license and operate. And we see no reason why any prejudice would befall the protestants if we were to be delayed, especially since settlement negotiations only kicked off in the last half of a week. We still think there's plenty of time for those substantive negotiations to happen, as there's time for the business and time for the parties to continue to discuss.
So is this a formal motion, Mr. Mixon, to continue this hearing, to give the parties an opportunity to continue talking?
Yes, Mr. Chair. And
Ms. Kramer, you're saying that You're not in agreement?
If I understand what's being said, and I'm not sure I do, we are not in agreement to not continue this hearing because we do not feel, given the issues that we are very eager to bring before the board, we do not feel that the conditions are ripe for finding a settlement agreement. I'd like the board to hear that. I think it's essential that the board hears what our experience has been and what our observation has been. I assume I understand that if we came in, even though the board would hear this, continue this as a protest hearing, that if we were mistaken or if the parties came together, you would be cheered by us coming to you with a settlement agreement. I mean, there's always a chance to do that.
I'm sorry, what did you say, Ms. Kramer? Well, let me ask you a question, Ms. Kramer. Would it benefit if we could order another mediation hearing?
Would it benefit if you could order a
second mediation?
I don't think so. I think that we are at a position where we have been at this this chore for several months at this point. We do not feel that there is reason to be optimistic that we will find a settlement agreement because we think there is great confusion between what we are trying to approve and what in fact lays ahead of us. That's the bottom line. And so we would like to have the board hear these arguments. If they then decide something different, that would be that's the board's both prerogative and expertise to do. But at the moment, we'd like the board to understand what the status of this license and license request is, and I think it's critical that you know that.
But as represented by the applicant, there's no immediate this establishment is not going to be open anytime soon because I guess there are other approvals because this is this is my position, what is it that you, the applicant, Mr. Mixon, wants to do today?
Continue the matter for a minimum of 2 weeks to provide the opportunity for the parties to exchange further settlement positions. Just to be clear, in terms of the actual time spent substantively negotiating, we replied to the first draft proffered on us over the weekend yesterday and have not yet heard a response to the proposed terms we offered. We would just like to get the opportunity to further work with the ANC, see if our proposals are acceptable, and if for whatever extent they are not, find whatever possibility there is of meeting in the middle. We don't think this is the kind of matter that merits a full hearing when there are only a small number of substantive issues on the existing draft agreement.
Ms. Kramer, I'm more this is the applicant who says that I want to talk to you. Normally, I don't get that. This is an applicant who says, "Oh, I believe that we can have a settlement agreement." ANCs are always saying we want to have settlement agreements, and this is a case where it's not apparent that they are ready to open in the sense that, and so therefore they're gonna, because a lot of times I've had hearings where the ANC is asking for continuance because we need further conversations. And the applicant will say, no, I'm not going to, I don't want to because you're delaying my plans to open. Here's a case where the applicant says, okay, we exchanged settlement terms. I believe that a settlement could occur. This is what the applicant is stating. And so I'm inclined to provide, if the applicant says that I'm willing to have further conversations with the ANC, because I think that it is better for the parties to speak outside of a hearing. because you're going to provide, the agency is going to provide this interpretation of a plan for business that is not open. And so I believe it's better if the parties continue to speak. More clarification would be provided to you of their plans. And so I'm inclined to grant the continuance based on the representation of the applicant, because if they request a continuance, I see no reason why it should not be granted, because they're giving up their right in the sense of what time their business would be open. So they are delaying the process.
I appreciate
Which they can.
I'm sorry, I appreciate
Go ahead.
your concern both for the applicant and for the ANC's position, and the fact that it is very clear from all the testimony we would hear, and perhaps will hear, that they're not ready to open. There's no question that there's room. The question is, and I will just cut to the chase, which I hope that we will have an opportunity to say in detail. This is preliminary to changing this into a Class C operation, which is an extremely confused situation. And without the board understanding that, and without the reason that we don't think that we are near a settlement agreement, which we absolutely would prefer, there's no question about that. We always do that because it's in our interest. And of course, it's in the board's interest. If we have a settlement agreement, you don't have to hear from us every time the licenses are renewed. And I mean, it's a wonderful vehicle. But the reason that we don't have a settlement agreement that is agreeable is because they cannot, if that's what their intention is, to open a further Class C operation, they cannot agree to the kind of constrictions that we have suggested in a settlement agreement. And the kind of constrictions we have suggested in a settlement agreement, let me be very clear, are typical of a liquor store in a residential area. We've not asked for anything special. We are not looking further for this, but we are in a very confused situation, and they know, and they have said to us directly, the lawyer said to us just last week, that as soon as they get this Class A license, they will apply for a Class C operation. We don't know where this operation is. We don't know the address. We do not know the space. We know nothing. I will outline all that. But unless the board hears that, we're just buying time, which is going to go no place. We will be exactly where we are now in whenever you call us back again. So
No, but all right, but Ms. Kramer.
Yes.
The application before us today is a Class A. If they want to change to, if we were to issue a Class A, and if they want to change to a Class C, then they would have to apply for substantial change, and then we would have to go to a hearing. We again would have to have a protest hearing on a Class C. So if they're saying that they want to have further conversations with you, if they want to change their application, they can do that. I mean, this is what they're asking for. And I think that if you're saying there's confusion, they're willing to have further conversations. I'm in favor of the parties having conversations so they can satisfy you, because you just can't change from a Class A to a Class C. Okay, that you're either a liquor store or you're a restaurant. You're not going to be both. So if they want to change if they want to leave from a liquor store, if we grant a liquor store license, and if they want to change to a restaurant, then it's going to be subject to placarding, and then we're going to have another protest hearing.
They're not. Let me make clear. I appreciate that. Let me be clear. They're not going to change to a restaurant. They're changing to a speakeasy, and that's their language, not mine.
But they can't.
It doesn't matter.
I'm saying there can't be a speakeasy with a Class A is a liquor store where you come in, you purchase. It's an off premises. You come in and you purchase and you leave. A speakeasy, whatever that is, it's my understanding that speakeasy is that you want to consume on premises. That's some type of on premises. So maybe you're talking about they want to change to a CT. So therefore, it's night and day between a liquor store and whatever. So this is what, all right. This is, and I've been doing this for 10 years, and I usually don't have applicants asking for a continuance because they want to spend more time to talk to the ANC. This is the first. There are two firsts I've had today. So that is my recommendation. The recommendation I'm going to make to the board. Go ahead, Ms. Kramer. Say
No,
what
no,
you want to
it's
say,
fine.
please.
I do appreciate what you're trying to, I really do. I'm not, this is not fluff on my part. I really appreciate what you do, what you're trying to do. And we will obviously abide by the board's decision. I think we will be where we are if we, and we will have lots of time to establish both the confusion and some clarity between it, if we have time. If that's the board's pleasure, obviously we will follow it. We don't have we have no problem now because we have no liquor store or speakeasy. We have nothing operating in that space. We actually don't even know where the space is precisely, which was one of our problems. So we have time to clarify all that. We can go back. If Mr. Nick Mixon feels that he is close to a settlement agreement, we'll find out what his closeness is and what ours is. Our responsibility is to represent the community and the residents who have spoken up. I will remind you also that this, if you do approve a continuance, this establishment or the license was never, as you know, properly placarded. Your investigator testified to that effect, and you have a report to that effect. So it gives lots of time for everybody to come together and to be informed properly, which they should have been. And we're happy to have that opportunity to do that. I am, as I said before, I'm simply eager for the board to understand why we found ourselves at this point, which is not characteristic of our interest to not have a settlement agreement. We want a settlement agreement that represents the community. The witnesses are here today. We hope they come back. They will be all able to come back when you reschedule this, assuming that you reschedule it. I mean, assuming that we are where we are in a future time. And I do want to thank the witnesses who are here, who have made a special effort to be here, and we'll try to have them back here again if that's what we find that we are confronted with. So we'll obviously abide by the board. I can't be more clear without spelling it all out, which you don't want me to you don't want me to make my case now, but the reason we're here is because of an unprecedented level of confusion and I don't know what, turgidness, the opposite, whatever the opposite of transparency is. And that's why we're here. And if we can write a settlement agreement for an establishment that will operate in the community's interest, we would try to do that.
And so, because Ms. Kramer, you talk about confusion. If there's confusion, we're not going to have clarity at this hearing today. So if there's confusion, I prefer that the parties continue to speak. They will clear the confusion. So at the end of this conversation, both the applicant and the ANC will know exactly what it is that has been proposed for the neighborhood. Okay, so what I am going to do now is that I'm going to make a motion that we continue this hearing that we continue the hearing based on the request of the applicant that the parties can continue to speak to clarify whether or not a settlement agreement can be reached. All right, is there a second?
Mr. Grant, I second the motion.
Mr. Grant has seconded the motion. We'll have a roll call vote. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Mr. Turner, agree.
And Mr. Anderson, I agree. The matter passed 6-0. So we are continuing this matter to give the parties more time to clarify what the issues are, whether or not this can be a settlement agreement can be reached. The board has 3 more hearings for this summer, so I'm not even sure if we'll have this hearing before the summer is. But it's at the owner's peril because they have requested this continuance. Yes, Ms. Kramer.
2 questions. First of all, are you likely to reschedule it during August?
I do not know, the board has, I do not know what the board's schedule is, but the board is scheduled to meet on July 29th, August 5th, and August 12th. And after August 12th, unless there's an emergency hearing, the board will not meet again until September 9th. I'm aware that the ANC probably doesn't meet. People in DC, everyone flees DC in August. That's why the board goes on recess on August 12th. So I'm not quite sure what's on the next 3 weeks and whether, I don't know what it is, but this is a motion based on the request of the applicant. So whatever delay, the applicant is amenable for this matter to be delayed so they can continue having more conversation and providing you, the ANC, with clarity on their view of what they want to bring to your neighborhood. And
Okay,
as I said, and I think this works better because what I've said, at the end of the day, if the board was to grant the license, you have to coexist. So at least if you've had an opportunity to have further conversations, if you're able to have a settlement agreement, that's best because you know their business model, and the board is not imposing something on you. You have had a conversation, so you know what this is a new business. And in order for a new business to succeed in any neighborhood, we need to have community buy-in. So I support, and I've always said I support settlement agreements. And Ms. Kramer, although you always come to these hearings to say, I'm new to this. No, I'm not even going to buy that anymore, Ms. Kramer. I am not going to buy that anymore. You're not new to this. You are a pro. Okay,
I don't know whether to take that as a compliment or not. I am not a pro.
That is a compliment, Ms. Kramer. I don't need to speak to Mr. Mixon because Mr. Mixon is an attorney, so I have expectations. And so if we have this here, I know you're not Ms. Kramer, but I'm going to have those expectations because you're no longer a rookie. Okay, you're no longer a rookie. You are a professional in doing this, and I respect both parties.
I hope I hope I can still behave as a professional. I do appreciate that. The only thing I will say also is that we stand where our commission does not meet in August either. So you have our formal protest, which stands until we can find another fork in the road.
And that's fine. And that's fine, Ms. Kramer. And you stated that there is issue with the placarding. As you're aware, the notice will remain. So it will remain. It should remain if it can during this period. So there should not be any issues regarding the placard. Okay.
Thank you. That's fine. That's fine. Okay. I do thank you, and thank you for the compliment, even though I don't think I deserve it, but that's okay.
You're welcome, Ms. Kramer. I just want to, Mr. Mixon, on behalf of your client, that you are amenable to have a settlement agreement, to have further discussion with the community about your plans, and I have to comment you on that because I usually don't have a lot of licensees who are willing to engage in settlement discussions. It's like most of the times it's like, okay, I don't want any conditions on my license, so let's go to the board, and I'm hoping that the board doesn't impose conditions. And there, at least what's presented to the board today is that the licensee or the applicant is open to have conditions on its license because it said it's open to have a settlement agreement. So
yeah, I let Cameron know that I'm open to working with the community. I let Miss Kramer know in our mediation that I'm open to working with the community. I also let Cameron know last week, if my license is approved and my lease is signed, I'm going to be moving to the community, so she wouldn't have to worry about what's going on in the community because I will be part of the community. I told her from the very beginning that this is something that I'm trying to get my family in order off of. This is something that we plan to be part of the community. We want to help out. We want to clean up. We want to give back. You know, it's just not a bad project. We're for the people. So I wanted to know that we're trying to settle. We're trying to figure out the best way. But I don't want her to, to keep on thinking that we're not. I'm willing to settle. I want to have an agreement. I want to be part of the community. I want the community to back my project. I don't want the community to be against me at any point.
All right. Well, thank you for the representation, Mr. Smith. And as I said before, if the parties are amenable, then I believe that a settlement agreement can be reached. And so I will ask the parties to continue to have meaningful discussions. And I'm hoping that I don't see you guys for this particular case, because it appears that the parties appear to be amenable to reach a common ground. And I think if the parties remain open, then they can achieve settlement. But if not, we'll have this hearing at some point. Okay. So have a great summer, have great conversations, and I would love to hear that this matter is canceled because the board, because a settlement agreement has been provided to the board for the board to approve. Okay.
Thank you, Mr. Chair. Members of the board.
Have a great one. Thank you.
Thank you. Thank you.
All right. And as Mr. Mixon stated, that it was a great day, so the board can go and enjoy the great day that Mr. Mixon stated that's out there today. All right, so since that is the only case that we have for this afternoon, so with that, let me close the record for the day. Let me find the appropriate reading to close the record for the day. Okay. All right. As chairperson of the Alcoholic Beverage and Cannabis Board for the District of Columbia, and in accordance with the Open Meetings Act, DC Official Code Section 2-571 at SEEK, I move that ABC Board hold a closed meeting on, hold a closed meeting on July 29th for the purpose of discussing reviewing ongoing or planned investigations of alleged criminal or civil misconduct or violations and obtaining legal advice from legal counsel on the matters appearing on the board's investigative agenda. B, obtaining legal advice and counsel and to review trade secrets, commercial and financial information related to matters appearing on the board's licensing agenda. C, obtaining legal advice and counsel and to deliberate on administrative judicial matters appearing on the board's legal agenda. D, discussing the logistics, regulation, and scheduling of the day's meetings. And E, reviewing personal matters and the administration of the district's alcohol and medical cannabis laws and regulations in accordance with DC Official Code Section 2-575B4, 11, 13, and 14, and 25-204.01B and C for July 29th, 2026, as published in the DC Registry on July 24th, 2026. Is there a second?
Ms. Quinn, I second.
Ms. Quinn, I second the motion. I will now take a roll call vote on the motion before us now that has been properly seconded by Ms. Quinn. Mr. Grant.
Mr. Grant, I agree.
Ms. Quinn.
Ms. Quinn, I agree.
Mr. Meadows.
Mr. Meadows, I agree.
Mr. Jones.
Mr. Jones, I agree.
Mr. Turner.
Turner, I agree.
As the motion has passed 6-0, I give notice that the ABC Board will hold this aforementioned closed meeting. Notice will also be posted outside ABCA's offices and the calendar on ABCA's website and published in the DC Register as soon as practical. It is now, the board, we're now adjourned for the day. We'd like to thank all members of the public who participated in our hearings today. and all our board members who actively participate in our hearings today. We're now adjourned for the day. I now ask all board members to return to executive session for further action. Good afternoon, and thank you.